Final case is Horne versus State. Mr. Upperman, I believe you represent the appellant.
May it please the Court. My name is Michael Upperman, and I represent the appellant Derrick Horne. I'd like to reserve 5 minutes of my time for rebuttal. I will focus my time this morning on the first two issues raised in the brief, and that is whether the trial court erred by preventing Mr. Horne from cross-examining the informant in this case, and whether the trial court erred by allowing the State to rely upon an alleged out-of-court identification made pursuant to a photographic lineup when the State failed to present the photographic lineup at trial. Regarding the first issue, the only witness in this case to tie Mr. Horne to the alleged drug sales was the confidential informant, Ricky Manuel. On cross-examination, the informant was asked how he got involved to be an informant in this case. And he responded that he was a passenger in a car when Sergeant Floyd stopped the car because Sergeant Floyd believed that the driver of that car was in possession of illegal drugs. The informant stated that later he had a family problem. He had an aunt who had apparently sold the family home to another person in the community for drugs, and that he wanted to be able to bust the person that bought the family home. So he approached Sergeant Floyd, and he asked Sergeant Floyd to help him in this regard. He stated that he was, quote, on a mission, and that he approached Sergeant Floyd to help him accomplish this mission. And then on the bottom of page 58 of the trial transcript, the informant stated that during the time that he asked Sergeant Floyd to help him bust the man who bought the family home, Sergeant Floyd brought up Mr. Horne's name, and Sergeant Floyd asked the informant to assist him in Mr. Horne's case. The informant testified that he felt like he needed to work for Sergeant Floyd in order to repay him for busting the man who bought the aunt's home. Defense counsel argued that the proper testimony was relevant to explain the informant's motivation to testify for the State, but the trial court sustained the State's objection and prevented the defense counsel from cross-examining the informant concerning the proper testimony. And as I've explained in my briefs, the trial court's ruling was erroneous. There's several cases that I've cited in the briefs. The main case is from the United States Supreme Court, and that's the Davis versus Alaska case. And the U.S. Supreme Court explained that the exposure of a witness's motivation in testifying is a proper and important function of the constitutionally protected right of cross-examination.
Mr. Elfman, and we sometimes speak in sequence about motivation and bias and these sort of things. We know about bias, but when motivation is used alone, and that's what you're talking about here.
Yes.
I have always understood that relates to a motivation to testify falsely. Would you agree that that's what the case law generally is talking about, where there is some motivation to testify falsely? I can understand this man had a motivation to cooperate with the police, but what is there about this circumstance that would suggest that his motivation would lead him to testify falsely?
Well, and that's why I don't know if I do agree that it's always a motivation to testify falsely. I think
if that's not the motivation, why does motivation matter?
Well, I think of course the defense wants to argue that the motivation is for something other than to tell the truth, and maybe we're saying the same thing. But I think the jury has a right to hear, and of course that's what all the cases have said, that in this type of case, where an informant is testifying for the State, the defense attorney must do everything he or she can to establish that that informant has some reason to come into court today to testify other than just for telling the truth.
I agree with you about that, and I don't know if I'd been the trial judge that I would have kept that from coming in. But I'm trying to figure out, if we assume that it was error to preclude the defense counsel from developing that in cross-examination, I'm trying to figure out how it could have made much difference, because so he was motivated to do this because this policeman had helped him work out a family matter. But why does that suggest that he's giving false information to the police, or that he's giving false information in court?
Let me answer the question two ways if I can. One, as far as the harmless error analysis, I think the State is relying on a number of factors where they're claiming the error was harmless, basically relying on sufficiency of the evidence. One of the factors the State's relied upon is that Sergeant Floyd observed Mr. Horne out in front of the trailer in this case. But of course, the actual testimony on page 98 of the transcript was that Sergeant Horne observed Mr. Horne 20 minutes prior to this alleged drug deal on October 7th. And of course, I submit that someone being at a location 20 minutes prior to a drug deal is not sufficient or wouldn't make the error harmless in this case. The state's also relied upon Mr. Horne's statement to Sergeant Floyd that he admitted that he sold drugs in his lifetime, or has sold drugs in the past. But of course, on page 97 of the transcript, Sergeant Floyd admitted that he did not ask Mr. Horne if he sold drugs on these two occasions. And in fact, the statement that Mr. Horne gave was on December 29, 2005, when he was arrested, more than 2 months after the alleged drug sales in this case. And there's also testimony about some marked money in this case. Sergeant Floyd said that every time he gave money to the informant to purchase the drugs in this case, the money was copied. Of course, if the law enforcement officers had arrested Mr. Horne immediately on October 12th, they could have searched him to determine whether or not he was in possession of any marked money to try to link him to this case. They didn't do that. They waited until December to arrest him. And then I've also relied upon the opening statement of defense counsel in this case. He told the jury that during this case, there's going to be a confidential informant that testifies, and that he would have the right to cross-examine him regarding his motivation. And when he attempted to do that, he was limited. He was not able to bring out this motivation. That's the first part of my answer. The second part kind of gets to, I think, what you were asking, why would this motivation have made a difference? Well, again, I think it goes to the fact that he's testifying during this trial, not because it's necessarily the truth, not because Mr. Horne necessarily is the one that actually bought drugs from him, but because he felt like he had to pay back Sergeant Floyd. He needed something. The something that he needed from Sergeant Floyd was to bust this person that bought his aunt's home. But in exchange, Sergeant Floyd immediately, in the same conversation apparently, brought up Mr. Horne's name, or brought up this case and said, "I'll help you, Mr. Manuel, Mr. Informant, but you need to help me. And you need to help me by going ahead and being involved in this case as an informant." And who knows how he took that. Maybe he took that, and I'm going to do whatever I can to come into court and maybe testify falsely. Maybe do whatever you need me to do to help you out because I feel like I owe you. I need to pay you back because you helped me by busting the person that bought my aunt's house.
What about this? What about maybe his motivation to assist the officer was a little stronger at the time of the buy when he identified the photograph, but it had faded some by the time he testified because he couldn't identify the defendant in court.
That's exactly right. So, and of course, as time passed, his motivation may have been stronger, or may not have been as strong. It certainly was stronger at the time. But nevertheless, it would explain what his motivation was. And again, in a criminal case, the criminal defendant has the right to cross-examine. I mean, this was the state's key witness. The critical witness in this case, the only witness that could tie Mr. Horne to these alleged sales. And defense counsel has to do everything he or she can to try to demonstrate that that witness is not here just to present the truth. That witness has some ulterior motive. And that's what the Davis case talks about. If there's an ulterior motive for this witness to be testifying, defense counsel has a right to question and confront the witness about that ulterior motive, and the failure to do so is a violation of constitutional rights. It's a violation of right to cross-examine. It's a violation of the right to confront a witness. I think the Tamango case that I've cited in my reply brief states that it's always an abuse of discretion to not allow that type of evidence in. I think the trial judge in this case actually ruled that the primary motivation for the informant was for the informant to get paid. That was on page 66 of the transcript, and I think that there's not anything to support that conclusion. And if you read the proper testimony, I think it's pretty clear that the informant's primary motivation in this case was because he felt like he had to pay back Sergeant Floyd. There was a deal that they had, and this was the second part of that deal to assist in Mr. Horne's case. I think the other thing that's noteworthy is that both the state and the trial court acknowledged that the evidence was relevant. Now, the state said it was remotely relevant. That was on page 65. And the trial court said that it was of limited relevancy. That's on page 66. But, of course, if it's relevant at all, then my client's rights of cross-examination and confrontation allowed that evidence to come in. The Holt case from the 5th DCA states that any evidence which tends to establish that a witness is appearing for the state for any reason other than merely to tell the truth should not be kept from the jury. Let me briefly address the photographic lineup issue. As Your Honor has already indicated, the informant could not make an in-court identification of Mr. Horne. So in order to establish identity, the state attempted to present this evidence regarding the out-of-court identification, the photographic lineup. But before the officer testified about the photographic lineup, defense counsel said, "I want to see the lineup." And the trial judge says, "Go ahead, show it to him." And that's when the state asked to approach, and the state says, "Judge, we don't have it here." And then the trial court asked defense counsel, "What's the objection?" And he said, It's extremely prejudicial. How am I going to cross-examine somebody on a picture I can't even see in my hand? There's no pictures. There's nothing here whatsoever. If they have an array, they could have brought it with them here today. The trial court overruled the objection and allowed the state to present the testimony about the alleged identification, and Sergeant Floyd later admitted that the lineup was either at the police department or he had disposed of it, and that was on page 104 of the transcript. Although the issue apparently has never been addressed in Florida, other jurisdictions that I cited in my briefs have held that the failure to produce a photographic lineup at trial violates a defendant's right of due process. Notably, the Fifth Circuit Court of Appeals has held that where the police fail to preserve the photographic array, there shall exist a presumption that the array is impermissibly suggestive. Mr. Horne asked this court to adopt those other holdings. Again, I submit that if a law enforcement officer fails to maintain a photographic lineup, then a criminal defendant, and more importantly, the court system, is prevented from scrutinizing the lineup. In this case, the informant described the seller of the drugs as having braids in his hair and having gold teeth. That was on page 77. Certainly, the court can imagine an impermissibly suggestive photographic lineup that would show only one defendant with gold teeth and braids in the hair. We don't know what this photographic lineup contained. We don't know if it even contained a picture of Mr. Horne. And the informant couldn't even identify Mr. Horne in court. And as I've cited in my initial brief, in my reply brief, jurisdictions around this country, in order to protect defendants' rights in this scenario, are adopting procedures whereby if the state wants to rely upon a photographic lineup, they need to introduce that lineup during the court proceeding so the court and the criminal defendant have a right to scrutinize that lineup to make sure that it was fair. And it wasn't done in this case. And if you throw out the out-of-court identification, there was no in-court identification, so the state would have been able to establish the identification factor or element in this case. I'll reserve the rest of my time for rebuttal.
All right, we'll reserve it for you.
May it please the court, my name is Meredith Carbula. I'm an assistant attorney general, and I represent the appellee of the state of Florida in this case. I'll, with the court's permission, address the issues in the order that Mr. Ufferman addressed them. The first issue is whether the trial court abused its discretion in limiting cross-examination or precluding the defense counsel from cross-examining Mr. Manuel on the specific issue of what prompted him to go to Sergeant Floyd, that is, that his aunt had sold the family home for $1,500 worth of cocaine. Mr. Ufferman noted that the only witness to link Mr. Horne to this drug deal was the confidential informant. I think the record doesn't bear that out. Sergeant Floyd testified that about 20 minutes before he dropped Mr. Manuel off at the Horne residence, he saw Derrick Horne sitting on the front steps of the mobile home. And Mr. Manuel testified he brought drugs from someone sitting on the front porch of the mobile home. This is not a case where Sergeant Floyd saw Mr. Horne at the junior food market in Havana 20 minutes before. In fact, he saw him sitting on the front porch of the Horne home. So I think there is other evidence. But I think more critical to this is that the jury heard that many things that would normally be considered impeachment evidence. They heard that Mr. Manuel was a 12 or 13-time convicted felon, and Mr. Manuel may have even exaggerated his criminal record. 12 or 13-time convicted felon. That he met Sergeant Floyd initially when he was a passenger in a car with a known drug dealer. That he had an encounter with Sergeant Floyd where Sergeant Floyd told him to stay out of trouble. And subsequently, he reached out to Sergeant Floyd for help with a family legal matter. Now, the jury heard all that up to, I went to Sergeant Floyd for help with a family legal matter. At that point, when defense counsel said, well, was it about drugs, that's when the state objected. And they went on the proffer and determined that the aunt had sold the family home for cocaine, and that's what motivated him to go to Sergeant Floyd. Also, Mr. Ufferman's brief relies on the fact that this was a quid pro quo. In other words, Sergeant Floyd, I'll help you if you help me. That's just not true. The record just does not bear that out. The witness on the proffer, mostly actually at the judge, specifically on page 59, the court, did he say something like this? I'll help you out on your aunt's situation if you will help me by making buys. I mean, is that how it went down? Witness, that wasn't the way it was presented to you. And then he goes on to say that after I mentioned to him about the guy that bought Mom's house, bought our house, bought it for drugs, and I told him the guy was, and I told him the guy who sells dope. This guy was not Derrick Horne. And if you're looking at motivation to testify falsely, one should look against motivation to testify falsely against Derrick Horne. There was no connection between this guy who bought the house for cocaine and Derrick Horne. It certainly wasn't him, and this deal where Mr. Manuel had bought drugs for Sergeant Floyd initially to bust the guy who did buy the home for cocaine. That happened about a year before trial, about 5 months before the buy. So
wasn't there another place in the transcript, though, Ms. Trabula, where the judge was asking questions and the defendant indicated that after he had gotten help from the sergeant, he felt he needed to keep going because that's the way he felt?
He said he felt he needed to keep going, but he didn't tie that specifically with, I mean, he may have felt a moral obligation. If one helps one out, a reasonable person might think they want to help that person. But the thing is, there's no indication that Sergeant Floyd or Mr. Manuel ever felt an obligation to testify falsely. In fact, Mr. Horne is not claiming that the CI didn't buy the drugs.
It's pretty clear he felt an obligation to this officer.
I think that he testified, yes, that he felt some sort of obligation to keep going, whether it was to continue to buy drugs and get drug dealers off the street or to help Sergeant Floyd initially.
Here's the problem I have with this, and I touched on it earlier, and I'll just tell you and help me with it.
I'll try.
This is a weak identification case. I'm not saying it shouldn't have gone to the jury. I'm not suggesting that at all, but it's a weak identification case. I mean, you've got an officer who rides by and sees the defendant on a porch, I think it is, out front.
Of his home. Of his home.
Right. And then 20 minutes later, I guess, a buy is made. This informant comes back and he says, I bought drugs from the guy on the porch.
A tall guy with, with plaits and gold teeth.
And I don't know if that ties into the way the defendant looked at trial or not. I don't have any idea. But maybe that's developed in the record, but I didn't see that it was.
Not as well as I would have liked it to have been developed.
So we've got, we have some tenuous identification testimony. He gets back in the car, I guess.
He does.
And the officer says he shows him photographs. And the defendant, this informant identifies Horne.
Correct.
But then, when the defendant is called to testify at trial, he doesn't see anybody in the courtroom that looks anything like the person he bought the drugs from. Now, he bought drugs from this man twice, according to what he said.
Yes, sir.
But he can't identify him in court. Well, see, here's the thing. It's a weak identification case. And if this had come out, the jury would have known that this is a guy who was really interested in trying to please this police officer who had helped him out with his family situation. And I think you realize it's a lot easier to say something, to cooperate with someone you want to please when you're just sitting privately with that person than it is when you come into court later on and are required then to make an identification. Some time had passed. And knowing that circumstances, seems to me the jury might very well have had some additional concerns about the reliability of this identification from this photo array if they had known about that relationship.
Well, I think, first of all, we do have in the record that defense counsel was permitted to ask the witness why he went to Sergeant Floyd. He went to Sergeant Floyd for help with a legal matter. The only thing that the judge excluded was the specifics that the aunt sold the family house for cocaine. There was nothing to preclude the defense counsel from saying, all right, the testimony was that he went to Sergeant Floyd for help with a legal matter. Isn't it obvious he wanted to help him? So the only thing that the trial judge found was that the specific problem, the aunt selling the home, was not was a matter that would distract the jury from the real issue. He did not preclude counsel from arguing that Mr. Manuel went to Sergeant Floyd for help with the family legal matter. That came into evidence. I also would like to point out, Your Honor, that when Mr. Horne came back after the second buy, he told, which came in with that objection, he told Sergeant Floyd, I bought the drugs from the same guy I bought the first time, Derrick Horne. So we have that identification. And it's not exactly like, I think the record bears it out, Mr. Manuel is looking in court, and I think this surprised the prosecutor, because there was evidence that both Mr. Horne and his mother had offered $100 to someone they thought the CI was after jury selection and before trial started. So I think it surprised the prosecutor, and the prosecutor suspected that Mr. Manuel may have been approached as well, though he certainly denied it. But he looked around the courtroom and he said, well, you know, I'm not 100% sure, so I don't want to say, you know, without being 100% sure. It's not like he said, as you put it, you know, Judge Allen,
right.
There's nobody in the courtroom that looks just like, you know, that guy.
Right. Well, I might have characterized, but he looked around the courtroom and he didn't see anyone that he could identify, and he said, no, I'm not going to sit here and lie about it.
I agree, and that's exactly what he said. But as I say, you know, and of course this out-of-court evidence rule, and is discussed by Professor Earhart, is that an out-of-court identification that happens immediately after the person has perceived the person is generally more reliable, and that's why we allow these out-of-court identifications. So we have an identification that occurred immediately after Mr. Manuel perceived Mr. Horne. He had been in his company 5 to 10 minutes the first time. Sergeant Floyd testified that he did not give any hints. And how we do know that Mr. Horne's photo was in the lineup is Sergeant Floyd testified that it was. And that was evidence that Mr. Horne was in the photo lineup.
Counsel, how would you apply the harmless error test, or suggest we apply it in this case? Assuming we find error in the cross-examination ruling.
I think you look at the harmless error in a couple of ways. Number one, that there was ample impeachment evidence to show that Mr. Manuel was not this, you know, a squeaky clean witness. Multiple felony convictions. Sergeant Floyd testified that the reason why he asked Mr. Manuel to be a CI was the fact that he hung around the drug element and was familiar with the drug lingo. I mean, what does that tell any reasonable juror, that he's into drugs, illegal drugs? That the jury heard that he was paid each time, in which the trial judge made a finding that that seemed to be his primary motivation. So they heard that. Then, so there was ample evidence of impeachment.
What exactly is the test, for example, as the Supreme Court discussed in Godwin or Goodwin? What exactly is the legal test to apply if we find that an error occurred on the cross-examination ruling?
I think you have to find beyond a reasonable doubt that the error didn't contribute to the verdict. And so that's where I think you look at the totality of the impeachment evidence that was actually presented, which was a lot, and the fact that the only thing that defense counsel was not allowed to inquire about was that the aunt had sold the family home for cocaine. They were allowed to inquire about why he approached Sergeant Floyd. That was to obtain his help with the family matter, and they certainly could have argued that in closing argument.
Mr. Arbulo, the argument about there was a lot of impeachment, and there may be a break in my logic here, but your argument that there was a lot of impeachment about this witness would make sense if you could argue that, well, the jury didn't believe him anyway. But in fact, the jury did believe him. I mean, this man could not have been convicted if this witness's testimony had not been believed by the jury.
I agree. And the fact is, impeachment is offered every day by defense counsel to try to convince the jury that it's not credible. I think when you look at the motivation, the justifiable ire of the witness that someone took his family home, he went to a police officer whose duty is to enforce law. And then the police officer said, and would you like to make more buys? Because he made some buys with the fellow that bought his home. And he said yes, and he paid them for them. That all came out in front of the jury.
So I would assume then, if this were a case involving the purported drug dealer who bought the defendant's,
Absolutely.
the CI's mother's home, had the trial court excluded it, you wouldn't be here arguing harmless error.
Absolutely not. Because clearly, if it would have been the person who bought the family home, admissible. If it would have been, if Mr. Emanuel would have been pending criminal charges and wanted to curry favor with Sergeant Floyd, admissible. It's simply, but that's not the case. The fact is that the only thing he excluded, simply because the judge felt it would distract the jury from the real issues, was that the aunt sold the family home. Not that he went to Sergeant Floyd for help. Not that he subsequently helped him. The judge let that come in. He went to Sergeant Floyd, I think it's page 54 of the record, for help with a family legal matter. The only thing was the detail about the aunt selling the family home for cocaine. If I could briefly talk about the second issue. First of all, on appeal, the defendant is claiming that the out-of-court identification presented by Sergeant Floyd should have been suppressed because the absence of the photo array creates a presumption of suggestibility or undue suggestion. That was not raised below. He objected on the grounds of hearsay. Defense objected. Of course, it's not hearsay because Mr. Emanuel did testify that he identified the person who sold him drugs from the photo array. Then Sergeant Emanuel testified about whose photo he picked out. So it's not hearsay. So the second thing is that he said, how can I cross-examine him without the picture in my hand? He didn't ask to strike the testimony. He didn't file a motion in limine to suppress the lineup. I mean, the lineup, this is not a surprise to him that there's a photo because it's in discovery. It's in the police report. So he didn't ask for a continuance. Sergeant Floyd said the lineup may be back at my office. He didn't ask for a continuance to ask the trial judge to make him produce the lineup and then litigate it further. That didn't happen. So I think primarily this court should reject this claim because it simply wasn't preserved for appeal. He argued it during closing argument vigorously and challenged it that how can this be reliable? So he had an opportunity to do it. He didn't preserve it for appeal, and I'm out of time. Thank you. Would ask that you affirm.
May it please the court. Just a couple quick points I'd like to make in rebuttal. First, the out-of-court identification in this case was the key aspect of the entire case. Without the out-of-court identification, the state would not have been able to obtain a conviction. The state talks about the ample impeachment evidence. That ample impeachment evidence did not go to this informant's motivation trying to curry favor with Sergeant Floyd, and that's the key to this case, trying to establish why would he make this out-of-court identification.
The jury heard that he got paid for it.
True.
The jury heard that he sought Sergeant Floyd's help for a legal matter.
Yes, but that's it.
Well, the jury heard he had 12 or 13 prior felonies.
The prior felonies don't go to whether or not he's trying to curry favor with Sergeant Floyd. If he was currently facing felony charges, yes. But, I mean, the fact that he's a convicted felon, of course, defense counsel can try to use that to impeach this witness. But the key is defense counsel needs to show why is he making this out-of-court identification in this case. Why would that be unreliable? The argument would be that he's attempting to curry favor with Sergeant Floyd. There's been a deal between Sergeant Floyd and the informant, and he's only following through on his end of the deal. And so, yes, the state talks about, he got to hear that there was some legal matter, and that's why he approached Sergeant Floyd. But then it got stopped because defense counsel tried to go further, tried to say, tell me about what was this issue that you approached Sergeant Floyd for? And the state objected, and they held a proffer, and defense counsel was never able to go into the details of that. That's the key here. The jury was left to wonder whether or not there really was this legal matter, whether or not there really was a reason for the informant to try to curry the favor of Sergeant Floyd. The state argues, isn't it obvious? No, the jury didn't get to hear the details of this agreement. And again, I think it is pretty clear that there is an agreement. On the bottom of page 58, the informant says, during the time that I stepped to him and asked him, discussed it with him. This is the issue concerning the aunt's house. He just went on, he brought this other guy's name up. The last case, the last guy, what I'm here for today. Further on, the state read a portion of the informant's testimony in the middle of page 59, where he said, after I mentioned it to him, Sergeant Floyd, the guy that bought my mom's house, and it's really his aunt's house, bought our house, he bought it for drugs. And then I told him who the guy was, and I told him about that the guy sells dope. And then that was it. Then that's when he brought this case up here that I'm here for today. It seems like it's the same conversation. Sergeant Floyd is saying, okay, I'll help you out, but you need to help me out. You need to help me out in Mr. Horne's case.
There's no testimony, is there, Counselor, that when he makes the identification from the photo lineup in the car, that he's been informed by the sergeant or the police officer, this is Derrick Horne, picture number 2.
True.
In other words, making that linkage. I'm following your train of thought, but in other words, you know who I want. I helped you on the house. Picture number 2 is Derrick Horne.
I think we don't know that. The jury, I think that goes to weight and not admissibility. I think the jury has a right to hear all of these details and sort out what effect that motivation would have had on their decision. Because, again, this is a weak identification case. It comes down to his out-of-court identification. Just quickly, the state relied upon the identification made for the second buy. And, of course, that was after the first buy had occurred, after there had already been this identification by the informant. And if that first identification wasn't proper for any reason, that would have tainted any second identification that the informant made. Thank you. I'd ask you to reverse.
Okay, thank you. Thank you both.